Now, this, I think, for many of us is a very important conversation because many of us may wonder how much privacy we are entitled to at work versus how much privacy our employer has. Now, can you or your employer record conversations and use them against each other if grievances occur? So to answer some of these questions, I'm joined now by Thabang Rapuleng, Director at Cliff Decker Hofmeyer Employment Practice. Thanks so much for coming through.
Thank you, Sakin.
Let's just start by establishing what the law says with regard to privacy as it pertains to employer and employee.
Well, I think the starting point, Sakina, is that every employer has a right to privacy. Obviously, you will appreciate that as an employer, you will have strategies, you will have your production lines and so on, that you have an interest to protect, an economic interest to protect. So there is that right to privacy. There is also a common law duty on employees to protect the interest of the employer. That's a good faith duty, to protect the interest of the employer. Yes, even employees do have a right to privacy, but that right to privacy obviously is restricted where the employee is engaged in the business of the employer or is using the facilities or the resources of the employer to communicate. So the right to privacy will generally be limited. And what you will find in most cases that these duties and these rights will be codified in the employment contract and in the employment policies of the employer. So that's where it generally starts.
Would it be fair to say, though, that the odds are generally stacked against the employee when it comes to these rights? Because surely the employer gets to decide what they do and do not put into the contract.
I think it will be fair to say that. I think it will be fair to say that. But they are stacked against the employees with justification. Because obviously, as an employer, you've started this business. You have this child that is your business to protect. And you are inviting this external party that you don't know. You're meeting them probably for the first time during an interview. So you will want to make sure that you build in safeguards to protect your interest. Hence, that the scales will not be equally balanced.
So if we take a few practical examples, a meeting, for example, and where people are talking, things are said, do you as an employee have a right to record such a meeting? And if so, under what conditions? Do you have to declare upfront that you will be recording this? Because we all have cell phones which have built-in recording devices. So it's very easy for you to go into a meeting and record it.
So generally, you do have a right to record a discussion or a meeting where you are party to that discussion. That's a general right. But in instances where the nature of the meeting is to discuss confidential issues, you will then at the very least need to declare upfront to say, I am recording this meeting, so that the employer can say yes or no. Because now you know that this is a meeting designed to discuss confidential issues. This is not just a general discussion. For example, if it's a meeting about strategy, there is justification for the employer to say, we don't want our competitors to be privy to this information. So they could say, we expect you to respect confidentiality in that regard. And in most cases, you will also have to check your employment policies as an employee. What do they say about recording meetings of the employer? If there is a policy that says you should not record meetings of the employer unless you've got permission to do that, then you are now obliged to obey the policy. So in general, yes, but in most instances, you will find that there are restrictions which are justifiable.
But that juxtaposition there, where you say in general, if it's a general meeting, does the employee need to indicate, do they need to basically alert the employer that they are recording this general meeting, or are they well within their rights to do so?
Well, in the absence of any prohibition in terms of policy of practice of the employer, they don't have to. But where there is prohibition put in place by a policy or a practice of the employer, then they will need to upfront declare.
And when it comes to things like monitoring your communication at work, what are the parameters there? If I'm using a computer that belongs to the organization, does my employer have the right to scrutinize every bit of communication that I partake in on their device?
In general, yes. In general, yes, because the device belongs to the employer. And in most cases, when you are given that device, it will come along with certain conditions, terms and conditions. They might be in the policy, or they might be communicated to you when you are given a device that says the device remains the property of the employer. The employer at any stage can recall the device. The employer at any stage could monitor what's happening in the device. So yes, the employers do have that right in general. Obviously, now it extends where you find that we also use the employer's devices to also engage in our own personal activities.
Like the cell phone?
Yes. If you choose to do that, that's the risk you're taking. It does not take away the right of the employer to monitor the device. So it's for you, if you say, I'm going to use this device for my personal purposes, that's the risk you're choosing. So it's an election you're taking. You've got the right to say, no, I will not use it for personal use. But if you do, it's a risk that you are taking. So employers can, and they generally do, monitor devices.
And is it a case of it can and will be used against you if the need arises?
Definitely. Definitely, and it's been used in most cases where you find that misconduct is found in the devices. In what is generally common, maybe in the insurance space, for example, you'll find someone exporting client information, client contacts to a future employer or a competitor, and they will be using the employer's device to communicate that or to forward confidential issues to their Gmail accounts and so on. Once they find such activities, then the employer can discipline you, and in most cases they will discipline you.
And what about cameras in the workplace, you know, where it can be pervasive, that your every move is watched? Does the employee have any sort of leeway, you know, to perhaps push back against that?
Yes. Obviously, if the cameras are there and you are made aware, alert as the employee that we do have cameras in your workspace, there is nothing wrong there. If you feel uncomfortable, then it means you are in the wrong employee. You are with the wrong employer. But if the employer says, we do have an interest to protect, we do know why we have these cameras in place, and we can justify that why we have these cameras in place. And it has since become a common practice in most employment practices, where you're going to find that there are cameras in place. So it will be difficult for the employee to push back.
But how far does that extend? Should we have cameras in the bathrooms, for example?
Definitely not. I think the right to dignity and the right to privacy still exists in the employment relationship. One will have to balance the interests of both parties. What is it that you are trying to protect as the employer, and to what extent can you go in protecting that?
Take truckers, for example, where they have these cameras installed now in their cabins, and they sleep there when they pull over. Is that allowed? Is that lawful? Is that something that they can fight?
I will say I'm not aware as to what's the justification behind it, but it's something that will not generally be applied in all sectors. I will imagine in that sector they will have some form of justification to say, why do we need this? And in some cases they might be saying it's for their own safety, where you find that trucks get hijacked and so on. But I must say I'm speculating here because I'm not privy to what the justification is. But I don't think that can be applied generally in all sectors.
Final one, random searches. You know, should one be subjected to random searches? Is that generally allowed as per the law?
Again, it will be the same situation where what is the justification? What's the rationale behind it? What is it that you are trying to achieve? What's the risk that you are trying to mitigate against? And are there no less invasive means for you to achieve that? Obviously, if there are less invasive means to achieve that, the employees will have ground to say, but you don't have to go to that extent. But where the employer can show that, no, this is the most effective or the most reasonable means that we have, that we can employ, then I will imagine it will suffice.
Well, thank you so much, Thabang Rapuleng, Director in the Cliff Decker Hoffmeyer Employment Practice, discussing with us some employer and employee rights with regard to privacy. Let's take a break.